Good evening, everybody, and welcome to this book launch today, which is being organized by the SOAS Arbitration and Dispute Resolution Center. And I have put in the chat our agenda for the day, the way we wish to proceed. And the I there refers to me, being Emilia Onyema. I would introduce myself shortly. And we are launching today Consumer Law and Policy on Faulty Goods, the latest book written by Dr. Nuhu Yidana. Dr. Yidana is a lecturer here at the School of Law, SOAS, and his profile, the link to his profile is in the chat. We have two discussants who are ably qualified to engage with the discussions in the book. So we do have Dr. Eghosa, Ekhator. He's my Nigerian brother, yet we're from different parts of the country, so I never ever pronounce his name correctly, so I have to repent quickly. And so his profile is also in the chat. Eghosa is a senior lecturer, an associate professor at the University of Derby. And then we have, coming out of Accra, we have Dr. Francisca Kusi-Appiah, who is a vice dean at the School of Law at the University of Professional Studies out of Accra. And she herself has also published in consumer law. So it's we have two very able colleagues to discuss and engage with Dr. Yidana's book. So the way we would proceed is I'm going to just quickly tell us about the center and what we do, and invite you to, I'll put the link to the center. If you're not a member of our center, if you would want to join, it's for now, it's for free membership. I'll put the link so that you can join. So my name is Emilia Onyema. I'm a professor of international commercial law here at SOAS, and I've had the pleasure of co-teaching with Dr. Yidana. And in preparing for this program, I then realized that I'm actually mentioned in the book. I didn't know that. So Dr. Yidana, I'm very, very grateful for that special mention. And so maybe that's what qualifies me to be chairing this session. So I'm going to be in conversation with Dr. Yidana, and the idea with the conversation is to understand. So we've agreed that he's going to tell us a little bit about himself. And when you start reading the book and you read the foreword, you'd get an insight into his own personal journey in academia. And then he's going to try to explain to us why he wrote the book. So we don't just write books because it's a fun thing to do. It takes a lot of sweat and tears and sacrifice. So he would explain to us why he wrote the book and who he wrote the book for. Any book or any piece of writing has a targeted readership audience. So he's going to try and explain that to us. And then very importantly, he's going to try to also tell us what, in his view, is what he thinks the book contributes to consumer law and policy making before our discussants would then begin to engage. And the way we've split it up is that Dr. Eghosa is going to talk about the obligations part of the book, which flows from chapters 1 to 3 on what is the requirement for consumer protection or for faulty goods. And then Francisca would then engage with issues around remedies. So, Dr. Yidana, you are the one we're celebrating this evening. So, who is Dr. Nuhu Yidana?
Thank you so much, Prof, for accepting to chair this particular important part of my book publication issue, and I'm very grateful. And also, I want to thank the discussant for also agreeing to, take part in this particular event. I'm very grateful to all of you. And Hannah, thank you for also setting up the entire processes. So, and Nuhu, my name is Nuhu Yidana, and I teach at the SOAS University, SOAS College of Law, University of London. And then I also I recently introduced consumer law, which I teach, which is also an inspiration drawn from this particular book that I actually write, which also draw inspiration from my doctoral thesis. And what actually motivates me to actually work on this particular project or this particular work is that today is we're in an era where goods that are produced in one jurisdiction can be found in almost all other jurisdictions. And by virtue of that, consumers all over the world have access to similar or identical goods. And by virtue of that, what it then introduces is that it then raises a lot of, both academic and practical questions regarding the degree to which the existing law protect consumers, particularly when a consumer acquires the goods or buys the goods and the goods are found to be faulty. What sort of a level of protection exists under the jurisdiction to ensure that the consumer is well protected. And my inspiration, the foundation of my inspiration has to do with most of the traders or sellers in the Ghanaian setup. You go to the shop and they indicate that goods purchased are not returnable. And in that context, once you buy the goods and the goods are faulty, you cannot return them. So a lot of consumers have, issues of being unable to return goods when the goods are found to be faulty. So the question I asked myself was, do we have adequate legal protection that exists in the regime? Vis-a-vis, we also have a lot of concerns about substandard goods in the market. And indeed, the former director of the Ghana Standards Authority had occasion to actually indicate that the incidence of substandard goods in the market is a national crisis. So, and once you buy substandard goods, the likelihood of the goods also becoming faulty easily is also very high. So that is what actually motivated me to think of actually inquiring into the existing laws we have in the country and to see, is our law adequate enough to actually provide sufficient degree of protection to consumers? And if the law is enough, what about the remedies that are available? What about the forum through which a consumer could seek redress? So by virtue of that, I engaged three key principal components of this particular book. So I looked at the obligations that is placed on sellers regarding the quality of goods, the remedies that are available for consumers if the goods are faulty, and the means through which a consumer could seek redress. And this is what I actually examined in this particular book. And I discovered that there are a number of shortfalls of the law in Ghana. And the question was, okay, so what sort of inspiration can we draw from other jurisdictions? And I decided to choose the English law. By virtue of the fact that our earlier Sale of Goods Act, which we currently draw protection from, was inspired by the earlier English sales law. And by virtue of that, and the UK now has their historical interaction with the EU, led to a lot of reform that has been introduced into the UK regime, ensuring that they have a more robust, sort of protection for consumers. So the argument then made is that, can we draw some inspirations while bearing in mind the domestic circumstances in the country? So, and that is what I actually engage in discussion in this particular book. Thank you.
Thank you very much, Nuhu. Yeah. And so you can already see the contribution. So for us at SOAS, we're already benefiting, our students are already benefiting you've been convening and you're teaching consumer law. Is there any other thing that maybe policymakers, having gone through the book, policymakers in Ghana may think about in the context of online shopping and online consumers doing a lot of transactions electronically?
Okay, thank you so much, Prof. So, what actually exists in our law currently deals with purely, in-person sales. So the part on online transactions is has not been actually captured. But again, if you happen to buy goods online and it's still within the jurisdiction, you will still be able to actually link up, rely on the various provisions to seek redress under the current law we have. But we also have the Electronic Transactions Act that deals with aspect of online transactions. But again, it's also not well developed. But that was not discussed in this particular book. Okay, and in terms of contribution of the book, policymakers, there are a number of key arguments that have been, made where a lot of reforms are needed, and those ones will need legislative intervention. And now where they will require parliamentary actions to ensure that the law is updated to provide the needed protection to consumers. Now, we also have judicial activism that will also be required somewhere along the line, because some are saying that the course interpretation could have actually been extended in a way, particularly looking at the same provision that exists in other jurisdictions and the way the same provision is being interpreted, which I feel, or I actually argued that the court could actually extend while waiting for parliamentary action. The court could, through judicial activism, could, take action in certain instances in ensuring that consumers are well protected. Which I actually argued in the book too as well. Yeah.
Perfect. Thank you so very much, Dr. Yidana. I think we're beginning to smell that a revamped, there will be another book, and one is you've already started mixing the ingredients to bake the cake. So we look forward to that. Eghosa, thank you so very much for coming on, switching on your camera. And because I'm coming to you now, Dr. Yidana has set out for us the motivation behind the book and what his hopes are, and we can see the outlines of a new book in the making. So I'm turning to you, Eghosa. You've looked at the first 3 chapters. You've looked at the current book. So what, please, for you to engage with your own assessment and your review of the book. You have 10 minutes. So we're running 1 minute before time, which is okay. But please go.
Thank you very much. I'm glad to be here, and I've known Nuhu for a very, very, very long time. So I'm happy to be part of this project. And for a lot of people, they'll probably be asking, what am I doing in consumer law, a background or consumer law project? Because many people know me as an international environmental lawyer, but originally I was trained to be an international business lawyer. So consumer law is something I've been doing for a long time. So just to provide a background, I think for me, when I looked at the book, what jumped out for me when I was going through like the abstract introduction, when Nuhu stated that the book evaluates the adequacy of the existing law for the protection of consumers when they are supplying faulty goods in Ghana. It talks about the analysis of the law in Ghana as compared with law in England and Wales. Specifically, Nuhu stated that the book offers a comparative diagnosis of the requirements for the quality of goods with respect to the obligations of traders of goods, remedies for consumers, and mechanisms for redress in Ghana. And the UK has influenced by a lot. For me as a Nigerian, as an academic in a UK university, as someone who has a bit of experience in consumer, I think what jumped out for me, even though this is supposed to be at the end of my talk, is like the book has got, and Nuhu alluded to that as well. This book is, even though it's focused on just Nigeria and Ghana and the EU and England and Wales, and with a bit of implications arising from the UK's membership of the EU. This book has implications for other common law countries. For example, in Nigerian context, several scholars like Professor Monye, they've actually said that Nigeria is a former colony of the UK. Many Nigerian statutes are modeled on English statutes. So the same argument that Nuhu has made in terms of protection of faulty goods, in terms of the Hire Purchase Act, in terms of the Sales of Goods Act, those similar arguments can actually be reflected in the Nigerian context. And also, in terms of the case law that Nuhu referred to, the Ghanaian case law, the English case law also has specific sort of value in Nigerian context. Those case laws also have some implications for the Nigerian context. So as for me, I think that was the first lesson that I took from the book. Then if you go into like the sort of the structure in terms of the specifics of the book, another thing which I found very interesting was the mention of the UN guidelines of consumer protection. So I think such UN guidelines, in terms of a lot of scholars who are doing consumer law protection, I'm not sure they're even aware of those UN guidelines regarding consumer protection, etc. I think for me as well, that is also a very, very important aspect of Nuhu's book, even though it's not an international law focus. But I think that the reference to the UN guidelines has a lot of implications for other sort of jurisdictions in other parts of the world in terms of the role of soft law. Can we rely on soft law to protect consumers? Can we rely, how can soft law, can the UN guidelines, for example, have implications in the African context, in the Nigerian context? And Nuhu talks about that from a Ghanaian context, and you could see the utility of the reliance of the UN guideline. Also, another key part for me that jumped out was when Nuhu stated that the book raises critical questions of both academic and practical importance as to whether there's sufficient protection under the existing law for consumers who are supplying the faulty goods. I think from what I've read so far in the first chapter, like the introduction, the second chapter talks about 2 and 3 talks about the Ghanaian code of context. I think Nuhu has answered that question to a very, very large extent. And he has tried to provide a very comprehensive analysis of the requirement for the quality of the good, remedies for consumers, and the mechanism for redress arising for the seller's supply of goods, which are not of right quality under sort of Ghanaian law. He also talks about how the Ghanaian law is inspired by English law, which at the same time, English law has also evolved as because of interaction with EU sort of framework. So you could see the connection, what Nuhu tried to achieve when he dissects the requirements of the law in Ghana, examines the identified gaps in light of UK law and his EU experiences, and also mindful of the unique circumstances in domestic setting in Ghana. There's no one-size-fits-all solution. That brings me to the sort of the methodology that Nuhu tried to do. And for a lot of legal academics, we are not really straight doctrinal legal academics. We are very, very wary of relying on maybe standalone explicit methodological sort of methodologies in research. And for me, I think the way Nuhu was able to justify why he was relying on comparative law methodology, why he selected the England and Wales, why he selected Ghana, what exactly was comparing, why did he choose the theme that it was comparing. That reliance on comparative methodology was a very, very strong sort of strength of the book, and was able to justify the rationale for choosing the English regime as an appropriate choice for comparative analysis in terms of the impact of case law from England and Wales, how those case law can actually be impactful in the Ghanaian context, especially when there are no similar sort of rulings in the Ghanaian context. Can Ghanaian judges, judiciary rely on those case law to have an impact to promote consumer law protection? And consumer law protection, if you look at from the current sort of world we live in today, everybody potentially is really a consumer now. So we need to also think of how we are going to protect the protection of consumers, and more often than not, in terms of whether the Ghanaian sort of context actually provides for the protection of consumers. So another thing which I was a bit unclear, which maybe I want Nuhu to clarify for me, when in terms of there's no explicit consumer protection law in Ghana. So I've done a bit of research in that regard. I think the sort of the overarching conclusion is that there's no standalone comprehensive framework in Ghana in terms of consumer law, but also there are some places which are found. Some people are saying that there is a 2012 consumer law in Ghana. Some are saying there's no consumer law in Ghana. So I think in terms of the clarity as well, that also needs to be very, very clear in that regard. But for me, what I've read so far, chapter 2 and 3, 1 to 3, Nuhu has actually set out, he's actually done something which is an original contribution to knowledge. He has written a very comprehensive paper on an area which ordinarily is quite dense in terms of you need to read a lot of cases, and he has been able to bring those cases relevance in terms from the Ghanaian context. And also, I think finally, even though it's just my overall sort of perspective on the book, I think the book is an important contribution to the discourse on consumer land protection in Africa, not just in Ghana. Even though this book is primarily based on analysis of UK and Ghanaian laws and legal frameworks, and if we centralize the lessons from Ghana, this book can also be useful to other African countries and other countries in the global south. Other common law countries in Africa can actually benefit from what Nuhu has done. So the lack of consumer protection is not something which is unique to Ghana. Lack of protection of faulty goods is something which is unique to just Ghana. Many African countries can actually take some ideas from what Nuhu has done and use that to better their own legal framework. So for me, I think Nuhu is just a start of something which you need to take forward in the future. You can start thinking of maybe doing a comparative study as well going forward between maybe Nigeria and Ghana, Nigeria and South Africa. How can African countries learn from each other? Also, if you live in an environment where funding is a massive thing in UK universities, I think for me, I think there's a lot of funding potential of what you've done so far, not just writing just the book. You can actually take this forward as well. For example, are you thinking of doing empirical research methodologies in the future? Also, is there any role for the ECOWAS, for example, or the AU in this regard? I think so what I've read so far, you've done something very, very great, and I'm very, very pleased to have had access to have read this amazing work by Dr. Yidana. Thank you very much.
Thank you very much, Eghosa, for your kind review of those first 3 chapters. Nuhu, I'm going to ask you to please respond to Eghosa's question regarding the statutory backing for consumer law and consumer protection in Ghana before Francisca gives us her response or her review.
Yeah, thank you so much. So there was a consumer protection policy that was adopted in 2014, and effort was being made for an act to be enacted, but that could not succeed. That could not go through. And as at 2018, 2019, a lot of draft work was done by the drafting department of the Attorney General and Minister of Justice unit. But unfortunately, it could not materialize. So early last year, 2 years ago, there was a promise to lay the bill before Parliament, but that again could not materialize. So as it stands now, what we have in place is still the Sale of Goods Act and then the Hire Purchase Decree with some little protection under the Electronic Transactions Act. So we currently don't have a Consumer Protection Act yet. Yeah, so that's what I'll respond to that. Yeah, thank you.
Thank you very much.
Yeah, and thank you so much.
Thank you. And Eghosa, I think in Nigeria we do have a robust consumer protection law and various policies.
Even the agency as well, the recently developed competition and consumer sort of body in Nigeria. That's something which maybe I think in the future can a comparative study between Nigeria's, instead of learning from the UK, for example, what can Nigeria learn from Ghana? And this goes back to what Professor Emilia has done in your own work as well, in terms of arbitration and customary law, in terms of the Kenya context and Ghanaian context, how arbitration, ADR also includes customary arbitration. So my own paper I've said maybe Nigeria can adapt or adopt that same idea from Ghana. So what stops Ghana from adopting or maybe taking the good from Nigeria? That sort of, maybe that's one way you can explore in the future.
Yes, and I fully agree, and thank you very much for that kind shout out of my own work, Eghosa. Francisca, I saw you a few minutes. Yes.
Yeah.
So as I had said, Francisca herself had published a book on. I'm going to get the title right. So she recently published a book on consumer rights and justice in Ghana, a legal compass safeguarding fair consumer transactions, and she's the vice dean, as I already mentioned. And so she's ably positioned to engage with the chapters on remedies, which we have in Dr. Yidana's book. Francisca, it's lovely to see you. Please.
Thank you. Same here. Good evening, everyone. Finally, good to see all of you. Put some faces to some names, especially Prof. Onyema and Prof. Eghosa. And to Yidana, congratulations. I first learned about you from Ekhator Cancer.
Thank you so much. Yes.
And he's still, I have published, but he's still the outstanding authority when it comes to consumer protection. So congratulations on this book, and it's a privilege to have the opportunity to review some of the few chapters. All right, so yes, your chapters are very interesting, especially the 4. It actually hits at the heart of everyday Ghanaian, so to speak, in the marketplace, because it actually tackles the dreaded moment, where a seller tells you goods sold are not returnable, basically. So, and that is what Yidana, you have brilliantly done very well by breaking down in chapter 4 the legal fiction of acceptance, rejection of goods, and remedies. Was highlighting the misunderstandings and misconceptions which are prevalent in Ghana. So you see that in terms of chapter 4, Yidana does very well. If you have the opportunity of reading, which everyone should get a copy, he examines faulty goods, okay? And that the issue here is, in Ghana, you have a right to reject faulty goods. However, you cannot reject goods which have just minor or trivial defects. And the reality here and the question is, what is trivial? That is a major issue, okay? Or what is a minor defect in Ghana? Well, he does very well. It throws more light for us to identify the fact that the law doesn't say anything about it. But of course, he goes ahead, he gives examples of how a buyer who buys, let's say, a brand new microwave, which starts working within a week, but he asks, should this buyer be denied any opportunity of returning the microwave because it's heating, even though it has now started turning or discoloring, in having the white turn into different colors? So this is very important. Again, in chapter 4, Yidana tries to also examine the issue of rejection of food. In as much as you have a right to reject food, you have to do it within reasonable time. So reasonable time, he deals with it. Again, it is not defined in Ghana. So it leaves consumers at the mercy of most of the aggressive sellers who claim you have used the product for too long. I must actually commend you, Yidana, for particularly tackling high purchase, which is a massive part of the Ghanaian informal economy. Trotros, taxis, home appliances, everybody basically uses it. And yet consumers are routinely exploited because they don't understand the difference between standard sale and a high purchase. Okay, so buyers don't own the assets until the final payment. So basically chasing damages on businesses.
Francisca is in Ghana, so
use of the item.
Okay. So the internet in Ghana is not as good as the one in Nigeria or Kenya. So Francisca, can you try? Don't mind me.
Right.
We
So
lost you for a few seconds.
Okay.
We
Can
can
you
hear
me
you
now?
Yes, we can. Please.
Okay. All right. So I was just saying, I was congratulating Yidana for his wonderful work when it comes to the high pitches that he tried to address, because it's a major aspect of our economy, our informal economy. But it's incredibly difficult to access remedies. And because I was saying, for us, the focus is on contracts and not on the functional use of the item. So, what are the available remedies? Obviously, rejection, termination, damages under the Sale of Goods Act and the Law of Contracts. And of course, under high purchase agreement, termination is the only obvious remedy available. In contrast, Dr. Yidana does very well by providing us a forward-looking approach, okay, offering a framework in Chapter 5 to improve these practices by incorporating the standard based on the UK Consumer Rights of 2015. But he puts a caveat there. The idea is not just to copy, but to adapt it for the Ghanaian buyer. So he has 3 solutions in Chapter 5, which is very interesting. That instead of us guessing what a reasonable time is, he is suggesting, why don't we also have the 30-day short-term right to reject? It saves everybody the struggle, of course. And then the second proposal, which is very good in Chapter 5, is that based on the English law, aside our usual rejection and termination, we should have repair, replacement, termination, and the termination should also come with what? Refunds, where there has been an attempt, of course, to repair and it has not worked. There should be some refund. And lastly, the third proposal he has, which is very ingenious, based on the EU concept of price reduction, is if you are stuck with a slightly defective item, the seller must reduce the price to match its actual degraded value, which is very, very important. So you can see here, Yidana does very well, okay, calling for legislative pragmatism, which is a bit in line with what the Consumer Protection Bill seeks to do. So he's right on point. Now to chapters 6 and 7. Yidana actually moves the readers, okay, all of us from consumer justice, from the law books, right into the marketplace. So here, it basically hits on a very essential issue, because it's one thing to have what? A legal right, and it's another thing to have the capacity to enforce that legal right. So the issue about having redress and yet having challenges in accessing the courts is examined thoroughly by Yidana in chapter 6. He points to certain challenges that consumers often face, the usual high filing fees. If it's not the filing fees, of course, the legal proceedings is really time consuming, as it would often include taking time off your work to go and sit in a district court in Accra or somewhere. And of course, aside that, the procedural traps. If you are not careful, of course, judges have the discretion to grant you remedies, even if you've not requested it. But if you're not careful and the judge is not a bit benevolent enough to grant you such remedies, you may lose out as a consumer if you are not able to plead those or make a request for those claims. But of course, in chapter 7, he makes some suggestions. Why don't we defer filing fees until after the consumer wins, just like it's done in the UK, which is brilliant. How about the digital courts? Can we use that? He gives the typical, the UK's money claim online, which is good. Although I have a question for Yidana, considering even now, you see how Professor Onyema drew my attention that the internet in Ghana is not as good as that in Nigeria. How do you now use the online as a platform to resolve cases? I hope you would be able to accept that. And of course, the use of ADR, alternative dispute resolution, is beautifully placed and examined in chapters 6 and 7. Yes, Ghana's laws and most of our judicial processes, we actually encourage that you go through ADR first. Now, the procedure in most of our lower courts and where a lot of the consumer cases, consumer right cases would go, which is the district court, because now there has been some amendments to the, how do you call it, the monetary jurisdiction, 500,000 Ghana cedis. So majority of the claims will be to the district court. So here, the first question the judge would often ask is, are you willing to go through alternative dispute resolution? So we often push for that. However, as Yidana clearly points out in his chapter 6, some of the mechanisms of the ADR system is a bit technical. So it often will be biased towards corporate traders as compared to just a single ordinary consumer on it. So of course, it's something to look at. And he raises the other important issue, which is customary arbitration, which our laws or our ADR Act promotes a lot. Of course, it would be beautiful to have disputes resolution of consumer issues through the customary law. But he also indicates that most through his own research, it's very difficult. The traditional leaders are not totally aware. Capacity has to be built. A lot of education has to be vested into that. I have a question for him that in the light of this, how do you get the chiefs, so to speak, to help resolve consumer issues without losing and then hastening the process for dispute resolution mechanisms, especially if you're using customary arbitration, without losing the essence of customary arbitration, so to speak? And of course, he ends it all with what? Education, advocacy. Even this platform is an advocacy. So we constantly carry out advocacy on consumer rights. And then we keep on saying, do you know your rights? Do you know your rights as a consumer? But who gives them the advice when their fridge breaks down? That's the question. Okay. And so he raises a very essential issue. We should try and empower them by giving free legal advice through legal clinics, which I'm hoping that, of course, our UPSC legal clinic will support you in that. Definitely, this is something we can do. So we are going to push for it. And so, in essence, as a whole, congratulations, Yidana. I know implementing these recommendations will go a long way to give us an effective system that will actively serve consumers in Ghana. Congratulations, and I hope I wish you the best. Thank you for.
Thank you so very much, Francisca. And I forgot to mention that she's the supervising coordinator of her university's legal clinic. And so we're sure that they would work a little bit more closely with Nuhu on how to ensure advocacy rights. And again, maybe the legal claims and simplifying how consumers can make claims. There's several examples out there. Nuhu, that's the impact that Eghosa was talking about, and the research grant application that Eghosa was talking about. So there's more work to be done. Nuhu, do you want to please answer the question that Francisca had posed on access?
Yeah, so thank you so much. Yes, thank you so much, Dr. Francisca Kusi-Appiah, for your kind kind comments and observations and pointers. I'm really grateful for taking your time to go into detail with the material, which is really I mean, and the nice part of you, I mean, to have done that. So in terms of the money claim online, which you picked on, and I think, you know, I'm sure you are aware already that we have the, I mean, so she practiced alongside, I mean, teaching, and I mean, so she's fully aware of the use of teleconferencing, where the call sit in Kumasi and handle cases from the north. And also, I think the courts in Accra also sit and then also handle cases from other regions too as well. And by virtue of that, they're tapping into technology to actually do this. So I believe that if we introduce money claim online, which we have in the UK, this has to do with specific amount of money involved. So once that is the case, then you'll be able to actually, we could, and again, if you look at it, we are not to transplant it wholesale because that will not work here. We have to adapt it, taking into consideration our domestic realities. And potentially, I believe it has prospect of helping to mitigate the limitation that is placed on persons being able to seek redress in court. Okay, so that is what I'm thinking. So, but we can still again engage it further. But I think if that is done, it could be helpful, and we need to adapt it, not necessarily transplanting what is available in the UK. Now,
yes,
I think
so,
the other, yeah.
Please go on. Please go on.
Yeah. So the other thing has to do with the traditional bringing in customary. Is that correct?
Yes.
Yeah, bringing in the. Can I get the question again specifically? So maybe.
Okay. So the question was, how do we train, let's say, our market queens, our customary chiefs to apply modern consumer law without ruining the speed and peace of traditional settlements?
Good, thank you. So that's what. So there you see that various regions now we have traditional, the regional House of Chiefs, where I think that they can have committees in place. For example, there are a number of chiefs who are well educated among them. There are some chiefs who are not educated, but because there may be disputes that will arise in their various communities, that is why you will see that I've argued that some kind of training could be provided to them in the local language in which they understand. So if that is done, what is happening is that, I mean, in the UK, where we have the various ombudsman coming in, and we have, I mean, we have the various ombudsman coming in. What they do is they don't necessarily apply the law, but they apply rules of natural justice more or less, even though they have the capacity to actually, I mean, understand or appreciate the various rules in terms of being able to, but they are not to interpret the law, but they may be guided. So in fact, they may be guided by the law. So if we provide education, we could build the capacity of our traditional rulers to perform similar things. So we are adapting it in a way, taking into consideration our domestic realities.
I think,
so that is what I would say in the context. I don't know if that's.
Yes, it's good.
Thank you so very much to both of you. And there is a lot to pick up from places like eBay and Amazon on disputes, resolving disputes, we have to try to make better use of electronic online dispute platforms. And then the cost is actually really important. But bearing in mind that quite a lot of sellers to consumers on the continent are very small retailers as well, that might impact on their ability to pick up the cost for the consumers. But there are various, I think there are various methods and systems out there that we can look at. Sorry, Nuhu, did you want to say something?
Yes, so I just wanted to add that, even in practice, we even have at the informal level, we even have that, I mean, such interventions happening. But if we then, I mean, empower them, build their capacity, then they can do justice to, matters that actually come to their attention. And in fact, you could see that there may even be an issue, and within the trading, within the market itself, influential personalities in there could also just even intervene in certain instances, particularly when the dispute is resulting to a conflict between the parties and they begin to even attack each other. They could come in to try to see how best they can resolve the matter. But these are informal way of actually seeking to resolve that. Yeah.
You're absolutely right. And I think Eghosa is still here, and I think we have a couple of Nigerian colleagues on the call. In just thinking of the informal sector where you have the markets, and each market has its own governance structure, where you have the market leaders. And so it's almost like a small community on its own and has some leadership groups that can, that's something to think about. Can they be used to resolve some of these disputes? And when you're thinking in terms of price reduction, which is something that is not well known within the common law system, if you're thinking of price reduction, who would determine what percentage of the reduction, what percentage of the price paid should be applied, and how do you deal with that, and what would be acceptable? And so these are the governance structure, at least within the market structures that we have in Nigeria, they are the ones that can come up with standards, and they may be standard setting, something that the seller would need to also accept. It will be easier for the seller to accept it if it is a range that is applicable within the market and within that particular trade. Eghosa, what do you think?
Thank you, Prof. I'll just need to add to what you've said. I think there's a very big potential in terms of what you're doing. It might be a gap, it might be an opportunity for Nuhu in terms of how the markets, the regular market traders, the people selling the faulty goods, do they have a legal framework? I'm going to mention Professor Anthony Diala. He's in South Africa. He has done a lot of work around market governance in Nigeria, in Somalia, and South Africa. Even this Igbo apprenticeship system, for example, is also. So I think if you conduct empirical study and go to a market in Kumasi and ask them, how do they regulate this? What does consumer law mean to them? So I think that's why sometimes what we see, the law in context, the law in practice, the law in the field might not be the reality of the law that we just studied from a doctrinal basis. So that's why I said empirical. If you go to the field, what we might think that are not existing, they may actually be staring us in the face. And that's the massive opportunity for you. You make just be formal and informal interview. Just pick 1 or 2, 3 market leaders. What are they saying? What are they doing? And you could do another book or another article from that.
Thank you very much, Eghosa. That's book number 3.
Thank you.
Professor Baderi wants to say something. Prof, please.
Thank you very much. Let me start by first congratulating Nuhu for the book. It's an important book because we are all consumers, one way or the other, and when our rights are violated, we want redress for them. Congratulations again. And by discussing book 2, book 3 is on the pipeline now.
Thank you so much, Prof.
I hope that also comes easy. I have one question. I don't know. I've not had the opportunity to read the book because I don't have it. I hope to be able to get it later and to read it. But one thing I want to ask is this. When lawyers, when we talk, we always talk about remedies. Remedies is after the fact, after violations have occurred. I don't know. I'm not very sure. I'm looking at it from the other end. That is a preventive. The preventive end. Now, for example, if you look at the UK and also I think Nigeria and some other parts of Africa, we have the standard organizations, that set standards for goods. Now, I mean, I don't know whether this is covered in your book in relation to now if the standard organization is doing good work, the tendency of having faulty goods might be reduced, that from the preventative end. Then secondly, we talk about people buy a lot of electronics these days. Electronics are most in the UK, for example. I mean, electronics come with automatic 1-year warranty. If anything happens to the electronics, you don't need to tell stories. It has happened within that 1 year. Well, the manufacturers or the seller will have to take it back without you. So I'm just looking at the preventative in relation to warranties and standards. I mean, I don't know what role does that play. It's not my area of specialization, but day-to-day things, I mean, these are, so I just thought I should ask in relation to preventive. Thank you. And congratulations again.
Thank you.
Thank you
Thank you
so
very
much.
much, Prof. And you have used, so Nuhu now has to make sure that you get a copy of this book, an autographed copy of the book. Nuhu, do you want to quickly answer or respond to Prof's point?
Yeah. Prof, thank you so much for making time to join us, and I'm very grateful for your comment. And indeed, you have an autographed copy, which, in fact, it's just that we were not able to meet on campus. This I had a trick to hand it over to you. So your copy will be handed over to you shortly. Now, and in terms of the regulatory aspect you've highlighted, yes, it's true. We have, like I highlighted initially, we have the Ghana Standards Authority that is in charge of, they set the standards. And in fact, sometimes they conduct market surveillances. And that was why the Director General, the former Director General, actually, they did some survey out of 204, different footwear. Only 7 of this footwear were found to actually comply with the quality standards. The others were all substandard goods. And electronics too, they found about 80 to 90% were also found to be substandard in the market. And that was when he declared that the idea of substandard goods in the market is a national crisis, which are actually highlighted in the book as well. Now, but interestingly, the focus of the book was not on the regulatory part, but was looking at where a consumer actually happened to acquire the goods, and then the goods are faulty. What do you do? So the mechanism, the regulators may have their regulatory structures in place, but now that we have the system being porous and the market is being inundated with so many substandard goods in the system, and a consumer happened to buy the goods, what sort of rights do you have? What sort of obligation do the seller have towards you? And what sort of remedy can you also assess? And that is what I actually engage in the book substantially.
Okay. And my eyes, we have less than 60 seconds. And so I think Prof has just, and you have identified that maybe there's a public law angle to this, and that might also engage issues around dumping and anti-dumping regulations. So that's book number 4. So we've basically set you up to do 3 more books. Our dean is on this call, so he's going to be very happy. Mark, I can see you have, my dean is very happy. So he has 3 more books coming out of Nuhu. Mark, I know that you can ask Nuhu your question because we have less than 30 seconds left. And I am struggling to say, Mark, go on, say something. Yes.
No, that's perfectly. Sorry, I'm so sorry. I'm even having a bit of a network issue myself. I just really wanted to come on record to congratulate Dr. Yidana, having stood by him as well in consumer law seminars as well before the students. A massive congratulations.
Thank you. I thought you had
so much,
burning question.
No, I do have a question, but I'll ask it. I would ask.
It's 6 o'clock.
Thank you.
Thank you so very much. So for those of you who do not know Mark Wasuna, he's one of our associate lecturers, and we all teach together. So as you can see, you can imagine what fun we get to have in class. And so we've, the group is set Dr. Yidana a target of 3 more books. Can I, Mark, can you take a photo? I don't know how they do the photo thing, so limitations. can we just, so we want to formally, Eghosa and Francisca, please can you come back on the screen? We want to formally launch Dr. Yidana's book, which I'm holding up. Hopefully you can all see it. And we are all saying a huge, huge congratulations to you again. And the center is very happy and grateful that you allowed us to host this book launch. So thank you, everybody. Nuhu, congratulations again. And thank you very much, Dr. Ekhator and Dr. Kusi-Appiah. Thank you. Thank you. Okay.